Alex here with part 150 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series, to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. This video could have easily been lumped into the last video. I decided to keep it separate for two reasons. The first reason is that it's a new judge who's entering this order, even though it's a really short order. It's like 3 sentences long. Again, that's why I would have just lumped it into the previous video. It is a new judge, and I thought it would be better to have a more clear, I guess, delineation between the previous judge on this case and the new judge on this case. And then the other thing is there are 2 affidavits that I discuss, and those discussions are pretty substantial. So even though the main document itself isn't that substantial, the judge's order, the judge's 3-sentence order, the affidavits are, because they go into why my first judge recused himself, and they also go a little bit into the creation and my control over our Nevada judges, both the channel and the website. So for those reasons, this is a separate video instead of being lumped into part 149. And all that being said, I suppose we should just go straight into what District Judge Bridget Robb has filed. Here we have District Judge Bridget Robb's first order entered in either of the 2 cases, and that order is, as I mentioned earlier in this video, a 2 or 3 sentence order. This is the order regarding ex parte motion that my attorney filed. She is indicating that based on District Judge Chuck Weller's recusal and our ex parte request to consolidate hearings for judicial economy, she mentions that since those hearings before Department 11 were vacated anyway because he recused himself, that this court in Department 13 is willing to accommodate the issues of the hearings before this court in one single hearing. These hearings will be set within the availability of the court. Next, she goes into certificate of mailing under Rule 5, indicating that this document was mailed to my ex and that it was provided electronically to my attorney. Next document. Here is the affidavit of John Hope Jr. This is an attorney who I assisted with his campaign. He was running against District Judge Chuck Weller. The reason that this attorney and I even met is pretty interesting. He knocked on our door out of the blue. And I remember my wife coming upstairs and saying, "Hey, there's this guy here who's looking for you." I found out by me, apparently I was on a list of voters. I mean, it's not like he knew me personally or he singled me out. And our Nevada Judges, the website, nobody even knew it existed back then. It had just been created. In fact, now I can't remember for sure if it was created before I met him or very shortly after I met him. I'm leaning towards it being made very shortly after I met him, like maybe within a couple of weeks. But in any event, he was at the door. He was just walking. He was just meeting people at their homes. It was pretty cool. I had never heard of judicial candidates doing this before. Anyway, I went out and I talked to him. I told him about the situation. And next thing I know, I'm offering to help him out with his website and stuff like that. This is a pretty brave attorney, in my opinion, because he did not have to prepare this affidavit for me. He could have just said, "Hey, I'm sorry about what happened. Best of luck to you and your case." But he didn't do that. He found out that my judge recused himself and that in the order of recusal, my judge insinuated that I couldn't be trusted or that my credibility was impugned or something like that. And he took a look at the order of recusal that the judge entered and he went ahead and made an affidavit. So let's look it over. First off, standard introductory, I guess you could call, sentences. Number one, he is over the age of 18, not a party to the action. Number two, that he is an attorney at law, licensed to practice law in the state of Nevada. That he directed me to design and implement a website under the domain name johnchopeforjudge.com, and that the purpose of the website was to support his judicial campaign for the Nevada 2014 elections, specifically for the 2nd Judicial District Court, Department 11, which is Chuck Weller's department, and that the content of the website was entirely dictated by himself and copied verbatim by me via electronic mail, communications, and handwritten designs, and that the opinions, statistics, and writings displayed on the website were and are entirely of his opinions, and that he is aware that I have also completed a second personal project, a website under the domain name www.ournevadajudges.com, and that he did not take any part in the design or implementation of the aforementioned website, nor did he have any affiliation with the website. He signs it, notarizes it, and certificate of service. This is interesting. Oh, this is okay. I was about to say, it's odd that this lawyer filed it, but he didn't file it. This was filed by my attorney. And this last page here, I wonder if she prepared the other portions of it. Anyway, and this last page here, anyway, indicates that this document was mailed to my ex. Next, we have the affidavit of Alexander Falconi. This is my affidavit. I have indicated that I am over the age of 18 and am a part of the action, and that I am a software engineering intern with extensive experience in web applications development, and that I prepared at the direction of Mr. John Hope a website under the domain name johnhopeforjudge.com, and that the purpose of the website was to support the judicial campaign of John Hope for the Nevada 2014 elections, specifically for the 2nd Judicial District Court, Department 11, and that the content of John Hope for Judge was entirely dictated by John Hope and copied verbatim via email, that the opinions, statistics, and writings displayed on his website were entirely the opinions of him, I was going to say himself, I guess you could say that, of himself, and that I only provided design and feature implementation, and that I also completed a second personal project under the domain name ournevadajudges.com, and that the purpose of the aforementioned website was to assist the voters in the 2014 judicial elections and does not contain my personal opinion, but merely displays statistical information provided by newspaper articles and the Nevada Supreme Court, which is true. And that the aforementioned website encompasses the state of Nevada in its entirety and contained information, cases, and articles on all district judges in the state of Nevada, including District Judge Chuck Weller, and that John Hope was not connected to the implementation and design of the aforementioned website, nor was he even aware of its construction until weeks after its opening, and that I can recall 2 individuals who contacted me through admin@ournevadajudges.com regarding Mr. Weller or Judge Weller's profile, but that they did not identify themselves as Weller campaign operatives, and that I nevertheless gave all due respect and consideration to the communications from this first person is Danny Denton, challenging case DV91-256, as posted to the profile on the basis that Judge Weller was not elected at the time, Exhibit 1, and that I nevertheless gave all due respect and consideration to the communication from Mr. Scott Bays. This must be another person. I don't remember this second person. I do remember the first person, but we're going to have emails from both, I assume, so we're going to go over those in a second. Anyway, challenging case DV91-256, as posted to the profile on the basis that Judge Weller was not elected at that time, Exhibit 2. And that we never reached an impasse regarding the issue, but rather Mr. Scott Bays and Ms. Danny Denton failed to get back to me regarding the documentation they were going to provide, and I assumed the cases to be valid, and that on July 9th, 2014, alarmed by the manner in which my credibility was being impugned by Chuck Weller's July 7th, 2014 recusal order, I contacted an attorney with experience in the court system who clarified that Department 11 did not even exist at the time DV91-256 was appealed, and that it was likely dropped into that department when cases were being rotated into Department 11 after the department was created. Based on this information, I removed DV91-256 from Weller's profile. In actuality, I just moved them over to a different judge. I moved them over to his predecessor. I don't even remember the guy's name. Anyway, that had a dialogue continued with these 2 operatives, I would have likely verify this information, and the profile would have been corrected immediately. And then the last section here is that I received communications from several candidates and judges, including District Judge Robb and Speaker of the Assembly William Horn, and that all the candidates and judges were treated with the same respect and consideration afforded to Weller's apparent campaign operatives, and that it was never the intention of the website to disparage or impugn Judge Weller. Next, we have Certificate of Service under Rule 5 indicating that this document was mailed to my ex. And then we have the exhibit index. We've got 2 emails, exhibit 1, exhibit 2. We have exhibit 1, which is an email, and this is the email from, let's start from the bottom. Where is their email? I can see here my response. Let's see here. So it says, thanks for your attention to detail. We take requests for correction seriously. The submission was unusual because it was not available on the Supreme Court of Nevada. The published opinion provided sufficient details to trace the case to District Court Case Number DV91-256, which reflects a published opinion that matched. We see Weller's name tracing back to 2000 with no judge's name listed before him. Perhaps he was sitting pro tem or appointed before the election. What I'm basically saying is he may have been sitting on the case prior to being elected. And then there is this person, Ms. Danny Denton, who says, I cannot seem to find anything regarding the case. Can you send me what you have? And then I give her the link here. And then it says the dates and parties match DV91-256. Information on this case can be found here. And then I give this case, or sorry, this docketing system. You can also feel free to submit positive articles on Judge Weller. Right now, we have a disproportionate amount of negative articles. This is a collaborative site, so we are taking submissions from all candidates and judges. This is a pretty open-ended email. This is not like a mean, angry email to this person who says she's a friend of my judge or who's just communicating me as a supporter of the judge. And this person didn't reply. This is where we left off. Let's take a look at the next exhibit. Scott Bays. So let's see here. This case, so it looks like the same thing. It shows Weller as the first judge with no judge before him. I'm not sure how it could have been anyone else, even though he was not yet elected. It is possible he was pro tem or acting on appointment. I don't think I will be able to change that case without a close look at the appealed order to see if another judge's signature is on it. So this guy says he was not acting pro tem by appointment or in any other capacity in Darren Mack versus Deborah Lynn Mack. What? Okay, so this is a very easy, this is even more infuriating. So everyone knows that the Darren Mack case is the case of the guy that shot Weller with a rifle. It is not that unreasonable for me to think that this is the same judge. Okay, so back in 2014, I didn't know all of that much about the court system as I do now. And so to see that the case at issue is a Darren Mack case is even more frustrating for me because I can totally understand why I would be confused and why I think that this would be Judge Weller's case. This is the guy who shot Weller with a rifle. This is not just some random case that I mixed up. This is just one of those situations where it is glaringly obvious to me that I was being reasonable. Anyway, this guy says that he will provide documentation ASAP. He doesn't get back to me. The other lady doesn't get back to me. Nobody gets back to me. And then all of a sudden, there's an order of recusal filed into the case saying that I'm a bad person. So as I read this email, I'm now even more angry than I was before. So what this person is saying is that Judge Weller inherited this case from a different judge. And that at that time, a different judge made the mistake, not Judge Weller. They didn't say any of this to me. So I'm sitting here reading through this email as I talk to you guys on camera, figuring this out on my own because these two individuals could not go above and beyond and respond to me. This goes back to what I stated in the previous video where I discussed the order of recusal. Judge Weller never wanted me to correct his profile. He never wanted me to get documentation supporting his claims. Judge Weller wanted an excuse to get off the case. If he didn't want an excuse to get off the case, these people would have gotten back to me with the documentation that I had requested. But they didn't get back to me. So I think that he used the website as an excuse to get off the case. And this non-impasse, because we didn't even reach an impasse, this was just his convenient opportunity to just not respond to me through these other people, through these third parties, to just not respond to me and then say, oh, look, Alex didn't fix what I told him to fix. Therefore, I can't trust his credibility. I am off the case. I'm just more convinced than I was now, especially seeing that the case at issue was Darren Mack versus Deborah Lynn Mack. I'm especially especially now under the belief that no wonder I thought this was Chuck Weller's case. Now, I the name of the wife doesn't sound right. I think that the case that stems from the shooting, I'm not just thinking, I am like 95% sure that it's a different person, a different divorce. So this is probably Darren Mack's prior divorce with a different spouse. That's what I'm thinking here. But again, guys, this is 2014 Alex. This is not 2020 Alex. This isn't the Alex that knew all of these details about the court system, that knew all of these details about the news involving the judges and the assassination attempt and all that stuff. This is 2014 Alex, and I think that the email communications back and forth with both of these political operatives were very reasonable on my behalf, on my, from my perspective. And I am not surprised at all that there was confusion regarding the Darren Mack case with this judge. None of this, to me, looks fishy. This looks like plain black and white back and forth communications where the judge and his friends decided to stop communicating back to me at a certain point in time and to just say that I was a bad person and therefore he's recusing himself. Next, we have the notice to set. In this document, my attorney is yet again setting a date to set the hearing for my motion to modify custody. The reason she's doing it this time is because the judge has recused himself and we now have a different judge with a different calendar. Next page is the certificate of service under Rule 5 with her indicating that this document was mailed to my ex. Here we have the notice of hearing. This is what happens when at the setting they actually pick the date and time of the hearing. And this is my attorney letting my ex know that the date of the actual hearing is November 4th, 2014 at 9 a.m. So this is for sure the date. This is a date that I'll never forget. November 4th is the date of the motion to modify physical custody. Next, we have the Rule 5 certificate of service indicating that this document was mailed to my ex. Here we have a subpoena commanding the dentist to appear in open court and testify as an expert witness. And I've already subpoenaed this witness, but this is just her issuing the subpoena again because we have a new hearing date and time. And next we have the instructions of the subpoena. And last we have the certificate of service, the affidavit of service. And this is indicating that a process server personally served the subpoena upon the dentist. If you want to know more about the importance of including the personal service affidavit and the instructions to the subpoena, which I just went over, please watch my video on the topic subpoenas. And also it'll cover little details like the fact that you have to give the witness a check and the amount of the check and all of that. Next document is another subpoena, this time for Leah Shubler, the dental hygienist, and pages 2, 3, 4, and 5 of this subpoena are the same as of the other one. It's the instructions to the subpoena and the affidavit of service. Again, guys, if you want to learn more about how subpoenas work, please watch my video on the topic. It is titled Subpoenas. Going into the aftermath, I filed, it looks like 1, 2, 3, 4, 5, 6 documents. Those were not all free. 2 of those were subpoenas. I had to pay the witness fee, and so the costs would come to $52. There would also be some change because you're supposed to pay 26 cents per mile, but I'm not going to go into that computation. It's going to be, a couple of bucks, probably $2 or $3. My ex didn't file anything, so she incurred $0 in costs. My ex didn't have an attorney, so she incurred $0 in attorney fees. My attorney would have probably spent about a half hour on each of those affidavits, I think. No. Yeah, she would have to review them. She would have to prepare them. I think a half hour on each one of them is reasonable. It comes to an hour so far. The notices, the notice to set and the notice of hearing, maybe not so much, but at the same time, she would have also had to spend time at the setting. She would have had to pick up the phone and coordinate with the administrative assistant of the judge and also with my ex. So that would be, I think, another 15 minutes each of those documents. So those total would come to 30 minutes. And with the hour from the previous documents, we are at an hour and a half so far. Then we have the 2 subpoenas. Those can easily be a half hour each, because she's going to have to coordinate not just preparing the document, but making sure that the process server has the instructions that he needs to serve those documents. So we're at an hour and a half so far. I think her review of the order on the ex parte motion, I'm going to just leave as negligible. It's like I said, a 3-sentence order, not a big deal. All they're doing is saying that the hearings were canceled anyway, so set them again. An hour and a half at the rate of $500 an hour is going to come to, actually, it was 2 hours and a half. if I remember correctly, 30, that's 1 hour. Yep, 2.5 hours at the rate, or sorry, 2.5, yes, 2.5 hours at the rate of $500 an hour. That's going to come to $1,250 in attorney fees for me. As with my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.